Hi, my name is Ed Sharkansky, and I'm a trial attorney who represents people charged with operating under the influence. And when people hear that's what I do, they initially think, how can you represent people who behave so dangerously, put us all in jeopardy? But the reality is, the large majority of people that I represent are people just like you and me. The reality is that in Massachusetts, if you've had even 1 or 2 drinks, maybe at a celebration like a wedding or a birthday party, you could be charged with operating under the influence. Since anybody can so easily be charged with operating under the influence, here's my advice for protecting your rights and being a responsible driver. First, very simply, don't drink and drive. Although it's not illegal to drink some alcohol before driving your car, it is illegal if you've had enough to drink that it impairs your ability to drive your car, or your blood alcohol concentration is 0.08 or greater. And if you've had even 1 drink, you can't possibly judge whether your ability to drive is impaired. And you certainly don't know what your blood alcohol level is. So, plain and simple, to be responsible, don't drink and drive. Points number 2 and number 3 we're going to speak about together. You have an absolute right not to present any evidence that can be used against you in a court of law. The government is going to ask you to take field sobriety tests, and they're going to ask you to take a breath test, and you have an absolute right to say no thank you to both of them. First, with regard to field sobriety tests, you do not know what the testing criteria are, and again, if you've had something to drink, you can't accurately judge whether you will be able to do those tests. So just say no thank you to field sobriety tests. Similarly, with regard to breath testing, again, you don't know what your blood alcohol concentration is going to be if you've had even 1 drink. So don't take the test. And with regard to both of those tests, the jury will never be told that you refused it, and there can be no inference that you're guilty because you said no thank you. That brings us to number 4. You have an absolute right to remain silent, and as you know, anything you say can and will be used against you in a court of law. When you're being investigated for operating under the influence of alcohol, the police officer is going to ask you questions. They want to know where you're coming from, where you're going to, if you've had anything to drink, and how much you've had to drink. The answers to these questions will haunt you at your trial. So to be a responsible driver, simply be respectful and cooperative with the police, but say no thank you to answering any of their questions. Finally, number 5, you have a right to an attorney, and you should hire an experienced drunk driving defense attorney. An attorney who specializes in DUI knows how to protect your rights. Pre-trial, an experienced drunk driving defense attorney knows how to potentially eliminate the evidence that could be harmful to you at trial. And at trial, an experienced drunk driving defense attorney knows how to expose the weaknesses in the case against you and persuade a jury to find you not guilty. Even after trial, an experienced drunk driving defense attorney knows how to handle the collateral consequences of your criminal record, your license suspension, and perhaps employment problems. So hire an experienced drunk driving defense attorney to protect your rights if you've been charged with driving under the influence. My name is Ed Sharkansky. I'm an experienced trial attorney, and I do this for a living. And those are my 5 tips to knowing your rights and being a responsible driver.